The morning I walked out of the Eloy Federal Correctional Institution, the Arizona sun was already brutal at 7:15. I stood on the sidewalk with a plastic bag containing my wallet, my watch, and a photograph of my granddaughter that I had carried for 19 months. The photograph was creased down the middle from where I had folded it to fit under my mattress the first week, before I learned the guards didn't care what you kept on your shelf. My granddaughter was 2 years old in the picture. She would be nearly 4 now. I did not look back at the facility. I had made myself a promise the day I arrived that I would never look back at it. Not once. Not even on the day I left. I kept that promise. I stood facing the highway, and I waited for the car that was coming for me, and I breathed the hot, dry air, and I told myself it was over. I told myself the part that nearly destroyed me was over, and the part that was going to matter was just beginning. My name is Richard Calloway. I am 64 years old. I spent 19 months in a federal correctional facility for a wire fraud and mortgage fraud scheme I did not commit, did not know about, and could not have stopped even if I had, because the person running it was my son. Let me start at the beginning, because the beginning matters. You have to understand who I was before any of this happened in order to understand how completely it took me apart. I built Calloway Development Group from nothing. I started it in 1987 with $40,000. I had saved working construction in Tucson, a used pickup truck, and a contractor's license I had studied for 3 months to earn. My ex-wife Patricia and I were living in a 2-bedroom rental in Chandler. My son Nathan was 4 years old, and my daughter Elise was 7. I remember Patricia ironing her nurse's scrubs at 11 at night and telling me this idea of mine was either going to save us or ruin us. And she said it without any particular emotion, just as a fact she wanted me to acknowledge. I acknowledged it. I told her I would not let it ruin us. She was right that it was going to be one or the other. For a long time it was neither. Just grinding. Just small residential projects and subcontracting work and bids that didn't come through. Until 2001, when Phoenix started growing in a way that nobody had fully anticipated, and I had positioned myself just well enough to catch the edge of it. By 2008, I had 43 employees and a commercial portfolio that included 3 retail strip centers and 2 mixed-use projects in the East Valley. Patricia and I had divorced in 2003, amicably enough, and I was living alone in a house in Scottsdale that I had built myself on a lot I'd bought in 1999 when the land was still cheap. My son, Nathan, had been working with me since he graduated from Arizona State in 2005. He had a degree in finance and a personality that could charm anyone in a room within 10 minutes. He was good at client relationships, good at presentations, good at the kind of soft skills that I had always had to work harder to develop. I was proud of him in a way that I am embarrassed to describe now, because the pride I had in him was the single most exploitable thing about me. In 2012, he married a woman named Vanessa. She was from Scottsdale, younger than Nathan by 3 years, and she had a talent for making you feel like the most interesting person in the room whenever she was talking to you. I liked her at first. I want to be honest about that. I genuinely liked her, and I told Nathan at the rehearsal dinner that I thought he had made an excellent choice. I meant it. After the wedding, Nathan asked me to give him a larger role in the company. He wanted to oversee the financing side of our residential development projects, the loan origination, the investor communications, the draws from our construction lines of credit. I thought about it for a week, and then I said yes. He had the finance background. He had been with the company 7 years, and he was my son. I told my business attorney, a man named Gerald Okafor, who had been with me since 2004, that I was shifting Nathan into that role. Gerald said very carefully that he thought we should put some internal controls in place. I told him Nathan was family. Gerald nodded and did not push it. I wish he had pushed it harder. The scheme they ran, as I eventually came to understand it, was not complicated, but it was patient. That was the part that still gets to me when I think about it. It was patient in a way that required planning over years, not months. What they did was create a series of limited liability companies, 6 of them, names like Sunstone Capital LLC and Meridian Holdings Group LLC, that looked on paper like legitimate subcontractors and investor entities that Calloway Development Group was doing business with. Nathan controlled all 6. He had registered them quietly. some in Arizona, some in Nevada, using Vanessa as the registered agent for several. Over approximately 2.5 years, he funneled just over $900,000 from our construction lines of credit and 2 investor accounts through these entities, booking the transfers as legitimate expenses, legitimate interest payments, legitimate consulting fees. He was meticulous. Every wire transfer had documentation. Every invoice looked real. He had even created websites for several of the companies, which I learned later were copied from real businesses operating in other states. What made all of this legally catastrophic for me was something I had done years earlier that had seemed completely routine. In 2009, I had executed a power of attorney giving Nathan authority to sign on company accounts and execute loan documents on my behalf. When I was traveling or unavailable, I traveled frequently. I had done this because it was operationally convenient and because I trusted my son. Nathan used that power of attorney to execute several of the largest fraudulent wire transfers himself, using my name in ways that made the transactions appear to have been personally authorized by me. When the FBI's Financial Crimes Unit began investigating Callaway Development Group in early 2018, what they found was a meticulous paper trail that pointed, at nearly every turn, directly at me. My name on the authorizations, my signature forged on some documents, obtained through the power of attorney on others on the transfer instructions, my company, my accounts, my projects. Nathan and Vanessa had spent 2 years building a frame around me that fit so precisely I could not find the edges of it. The morning 2 FBI agents knocked on my door in Scottsdale. I was drinking coffee on my back patio. I remember that very clearly. I had a cup of coffee and I was looking at the pool and thinking about a problem we were having with a subcontractor on a project in Gilbert. The agents were polite and professional, and they told me they needed to ask me some questions about financial transactions related to my company. I let them in. I answered every question I could. I showed them my computer. I called Gerald and put him on speaker. I was not arrested that day. The arrest came 6 weeks later, after the investigation had progressed. I was taken in on charges of wire fraud, bank fraud, and money laundering. The indictment was 22 pages long, and it named me as the sole architect of a scheme to defraud investors and a federally insured financial institution. Nathan was not named. Nathan had, by that point, given a proffer statement to the government, in which he described himself as an unwitting participant who had only later come to understand that I had been using company accounts to enrich myself. Vanessa had given a similar statement. They had lawyered up months before I even knew I was under investigation. And the lawyer they had retained was very, very good. I want to tell you what it felt like to read my son's proffer statement, but I'm not sure I have the words. There is a kind of injury that doesn't have a name because the human body and mind were not designed to survive it. Reading those pages in my attorney's conference room on a Tuesday afternoon in October 2018 was that kind of injury. Nathan described conversations we had supposedly had about hiding money. He described me directing him to set up the LLCs, which was a lie so absolute and so detailed that I read it 3 times trying to find some possible version of events in which he was confused or misremembering. There was no such version. He had sat with federal prosecutors and a defense attorney, and he had told them, carefully and specifically, things that had never happened. My attorney was a woman named Diane Ferris, one of the best criminal defense lawyers in Phoenix, and she did not sugarcoat what we were facing. The documentary evidence was devastating. The government's forensic accountants had traced every transfer. The fact that my name appeared on the authorizations was something we could potentially explain, but explaining it required the jury to believe Nathan was lying and I was telling the truth, and Nathan was going to be a prosecution witness who came across as cooperative, remorseful, and credible. Juries, Diane told me, tend to believe cooperative witnesses. I asked her what our chances were. She said she had seen worse cases result in acquittals, and she had seen better cases result in convictions. She said she needed me to think carefully about whether there was anyone who could corroborate my account of how the financial management of the company actually worked, anyone who might have independent knowledge that the LLCs were not something I had ever discussed or authorized. Gerald Okafor could testify to some of it. A former office manager named Beverly, who had left the company in 2016, remembered Nathan explicitly telling her not to discuss certain vendor payments with me, which she had thought was odd but had not reported. That was useful, but not conclusive. What I did not have was a forensic accountant who could reconstruct the digital evidence in a way that showed Nathan's exclusive access to and control of the fraudulent accounts. I did not have that because retaining a qualified forensic accountant for the level of analysis we needed would cost between $40,000 and $60,000. And by the time I was indicted, the government had frozen my personal accounts as proceeds of alleged criminal activity. I had liquid assets. I had a good life, and I could not access enough of them to properly defend myself. I was convicted on 7 of 9 counts in February 2019. The jury deliberated for 2 days. When the foreperson read the verdict, I was looking at my hands on the defense table, and I remember thinking, with a strange calm that surprised me, that I had to survive this. Not for any abstract reason. My granddaughter, Nathan, and Vanessa's daughter, Emma, had been born 7 months earlier. She was 7 months old when I was convicted of crimes her father had committed. I remember thinking that she needed someone who was not complicit in what had happened to me, and that the only person available for that role was me. The judge sentenced me to 4 years. Diane filed an appeal immediately. I was remanded and transferred to Eloy. The first weeks were the hardest. I am not going to describe them in detail because some of what happened to me in those weeks belongs only to me and will stay with me. What I will tell you is that I came very close, in that period, to deciding that surviving was not worth the effort. I want to be honest about that because I think there is a dishonesty in these stories when they skip over that part. The part where you are lying in a bunk at 2 a.m. and the weight of what has been done to you is so total that continuance seems optional. I came close to that edge. I want you to know that. What pulled me back from it, in a practical sense, was a man named Walter Briggs. Walter was 61 years old, a former certified public accountant from Tucson, serving a 5-year sentence for tax fraud related to a client scheme he had admittedly participated in and felt genuinely remorseful about. He had been at Eloy for 3 years when I arrived. He had a bottom bunk in the same unit and a habit of reading thick nonfiction books and an opinion about everything, which he shared whether or not you indicated interest. Under other circumstances, I might have found him exhausting. In the circumstances I was actually in, his relentless engagement with the world around him was the thing that kept me tethered to that world. Within 2 months, Walter had essentially decided he was going to help me whether I wanted him to or not. He had reviewed what I was able to tell him about the financial structure of the case, and he said, without any drama, that it sounded to him like the digital signatures on those wire authorizations were the key issue, and that if I could get someone on the outside to look carefully at the metadata associated with those authorizations, specifically the IP addresses and device identifiers logged by the banking platform when the transactions were initiated, there was a reasonable chance the picture would look different than the government's forensic accountants had described. I wrote to Gerald. Gerald talked to Diane. Diane had already been down a similar path but had been unable to afford the level of technical analysis that Walter was describing. I asked Gerald to explore whether there was any path to funding a renewed forensic analysis. He told me he would try. In the meantime, something else was happening. Vanessa had, apparently, not been content with the $900,000 that she and Nathan had stolen from my company. This is the part of the story that I find almost impossible to explain to people without them asking me how I feel about it. And the honest answer is that I have very complicated feelings about it. What I feel most clearly, when I sit with it, is something close to a cold vindication, not satisfaction. Exactly. More like the feeling you get when a very long equation finally balances. What Vanessa had done, beginning sometime in 2019 and accelerating through 2020, was to take approximately $2 million from Nathan's clients. Nathan had, with the stolen money, started a small private wealth management firm by convincing them to invest in a high-return promissory note program that did not, in any recognizable sense, exist. It was a classic Ponzi structure. Small at first, then larger as early investors were paid returns from new investor money. By the time the first clients began asking serious questions in late 2020, Vanessa had moved most of the money into accounts that Nathan either did not know about or claimed not to know about. The SEC and the DOJ opened an investigation in March 2021. I did not know any of this was happening. I was at Eloy. I had access to a phone for limited hours and a correspondence channel that moved slowly. What I knew was that Diane had filed a motion to reduce my sentence based on new evidence arguments, and that the motion had been pending for what felt like a very long time. The information came to me through Gerald in the summer of 2021. He wrote me a letter because the subject matter was sensitive enough that he did not want to discuss it on a monitored call, in which he told me that he had been contacted by a DOJ attorney who was working the Vanessa investment fraud case and who wanted to speak with me about what I knew about my son's financial activities prior to my conviction. Gerald said he believed this contact was significant. He said he thought I should agree to speak with them. I agreed. 2 weeks later, I had a meeting in a conference room at the facility with a DOJ attorney and an FBI agent who were working the new investigation. They were polite and very precise in their questions. I told them everything I knew, which was, unfortunately, not much about the new scheme since I had been incarcerated when it occurred. But I answered their questions about the structure of Callaway Development Group, about the LLC entities that had been used to frame me, about the power of attorney, and how it had actually been used in practice. The DOJ attorney listened very carefully and took detailed notes. 4 months later, Diane filed an emergency motion for new trial based on evidence that had emerged from the government's new investigation of Nathan and Vanessa's Ponzi scheme. The digital forensics work performed by the government's own technical team in the context of that investigation had, as a byproduct, produced analysis of the same banking platform used in the original fraud. That analysis showed clearly what Walter had hypothesized 2 years earlier. The IP addresses and device identifiers associated with the fraudulent wire authorizations in my case were consistent with a laptop registered to Vanessa, not with any device I owned or had ever used. The forensic accountant who had testified at my trial had not run that specific analysis. Nathan's attorney, when negotiating his proffer, had made sure the investigation stayed narrowly focused on the documentary trail that implicated me. I was released under an order vacating my conviction in September 2022. The court issued a statement indicating that newly discovered evidence materially undermined the reliability of the verdict. I received an apology from the court that I will not discuss here because what I think about that apology is not something I am going to put into polite language. Nathan and Vanessa were indicted 4 months before my release on the new Ponzi charges and, as a result of what the investigation had uncovered, on new charges related to the original fraud and the conspiracy to obstruct justice by framing me. Their combined exposure was substantial. Vanessa ultimately entered a guilty plea. Nathan's case went to trial. He was convicted. I found out he was convicted on a Thursday afternoon. Gerald called me and told me, and I said thank you, and I ended the call and I sat in my kitchen for a while, looking at nothing in particular. What I felt was not what I expected to feel. It was not relief or satisfaction or any emotion with a shape to it. It was more like the absence of something that had been pressing against me for 3.5 years. A release of pressure. Like a window opening in a room where you hadn't realized how stale the air had gotten. There are things people want to know when they hear this story that I am going to address directly because I've had these conversations enough times to know what's coming. The first is whether I have sued for wrongful conviction. Diane and I discussed this extensively in the months after my release. The answer is that the legal landscape for wrongful conviction civil claims against the federal government is genuinely difficult, not impossible, but difficult, and that the emotional cost of continued litigation was something I weighed very carefully against the financial outcome. What I will say is that there are proceedings ongoing that I am not going to discuss in detail. I do not want to say more than that. The second is Walter Briggs. Walter was released from Eloy in January 2022. 8 months before I was. When I was released, I called him from a phone number Gerald had provided. We had dinner in Tucson 3 weeks after my release. I sat across from him at a diner on Speedway, and I told him that I was not sure I would have survived those early months without his engagement and his stubbornness, and he waved his hand and said I probably would have been fine, and changed the subject to something he had been reading. He is working now as a financial consultant for a non-profit that provides forensic accounting analysis to indigent defendants in white-collar criminal cases. I supported that organization financially at the first opportunity I had to do so. I will continue to support it. The third is Emma. Emma is 4 years old now. She has dark hair and a very serious expression when she is thinking about something, which is often, and she calls me Pop. I do not take that for granted. Not for a single minute. When Nathan and Vanessa were arrested, Emma was placed initially with Vanessa's mother, a woman I had met only a handful of times. I retained a family law attorney and filed for grandparent custody within the week. The process took 4 months. Vanessa's mother did not contest it aggressively. What she said in our one direct conversation, which I appreciated for its honesty, was that she was 67 years old, and she did not have the energy to raise a 4-year-old, and that she believed Emma would be better off with me. Emma has been living with me since February 2023. I had set up a college savings account for Emma when she was born. It was funded modestly at first, $25,000, with the intention of adding to it each year. When my assets were frozen pending the investigation and then the conviction, I had been unable to add to it, but the original contribution was in a separate custodial account that the government had not included in the asset freeze because it was registered in Emma's name with me as custodian. Nathan and Vanessa had, at some point, apparently tried to access it, but the custodial structure prevented them. That account, with modest growth over 5 years, was intact. Emma will go to college. I will make certain of that. The house in Scottsdale I sold. I needed to liquidate it to cover legal fees and to start over without a building that carried 5 years of the worst memories of my life attached to every room. I bought a smaller place in Sedona with a view of the Red Rocks and a yard big enough for a 4-year-old to run around in. The first morning I woke up there, I made coffee and sat on the back steps and watched the sun come up over the rock formations, and Emma came outside in her pajamas and sat next to me and asked me what those big red things were called, and I told her they were called buttes, and she said that was a funny word, and I agreed that it was. The business is gone. Callaway Development Group, 43 employees, 35 years of work. It dissolved while I was incarcerated. I do not spend energy mourning it, because I found out during those 19 months at Eloy that the business was not the thing I valued most about the life I had built. It was a significant part of that life, but it was not the foundation of it. What was underneath the business, what stayed intact, even when everything else was stripped away, was a set of convictions about how to behave toward the people in your life. I did not compromise those. Not once. Not in any direction. I am prouder of that than of anything I built between 1987 and 2018. I have received letters from Nathan. I have received a phone call, which I did not answer, and voicemail messages, which I have listened to exactly once. In the most recent letter, written from a federal correctional facility in California, he described a process of self-examination that he characterized as genuine, and he asked me whether there was any possibility of a conversation. The letter was not without substance. I could see in it traces of the intelligence and the emotional acuity that had made him effective at his job and that had also made him devastatingly effective at framing me. Those traits did not disappear because he was incarcerated. They adapted. I wrote back one sentence. I told him that I did not have anything to say to him. I want to be careful here about something, because I think this part of the story is where people who are not in it have the strongest opinions. People want to know whether I am wrong to refuse contact, whether I am depriving Emma of a relationship with her father, whether forgiveness is something I owe myself, regardless of what I owe him. These are real questions, and I take them seriously. What I have concluded, after thinking about them for more than 2 years, is this. Forgiveness is not a single action you perform once, and then you're done. It is a practice, and it is one I am engaged in, imperfectly, for my own benefit, not for Nathan's. I think about what he did, and I feel the specific gravity of it, and then I choose not to let it occupy more of my present than it has already occupied of my past. That is the version of forgiveness available to me. It does not require contact. It does not require conversation. It does not require me to expose Emma to a relationship with her parents before she is old enough to make informed choices about what she wants from them. When she is old enough to ask questions, I will answer them honestly, and I will help her form her own conclusions. What I will not do is pretend that what Nathan did was something other than what it was. It was a choice. It was a sustained, deliberate, patient choice, made over years. He built the frame, one piece at a time. He watched the investigation focus on me, and he said nothing. He sat across from federal prosecutors, and he described things that had never happened, in a voice I can still hear in my memory, steady and articulate and false. He chose that. He can live with having chosen it. I am living with what I chose, which was to survive, and to rebuild, and to be present for a 4-year-old girl who has a serious expression when she is thinking, and who calls me Pop, and who deserves at least one adult in her life, whose word means what it says. On the morning I walked out of Eloy, before the car arrived, I stood on that sidewalk and I looked at the photograph I had carried for 19 months. Emma was 2 in the picture, in a green dress, sitting in a patch of sunlight on what I recognized as the rug in Nathan and Vanessa's living room, and she was looking at something outside the frame with an expression of absolute concentrated interest, as if whatever she was looking at was the most important thing that had ever existed. I had looked at that photograph so many times over those months that I knew every crease and shadow in it, and I stood there in the early morning Arizona heat, and I looked at it one more time. Then I folded it carefully and put it in my shirt pocket, and I waited for Gerald's car. I did not look back.